Hello, welcome back to Legal Eyes. Today, I'm going to tell you everything you always wanted to know about testifying, but were afraid to ask. Maybe you're an accused person, maybe you are a witness, or maybe you are just one of those people who like to prepare for anything. Possible earthquakes, or what would happen if you ran out of toilet paper, or what if you were called to testify in court? If you actually have to testify in court, it would not be surprising that you would be very nervous. After all, public speaking is the number one fear most people have. It is not fun to get in front of everybody and start saying something because what if you make a mistake? What if you say something stupid? What if everybody laughs at you? Or in court, what if you go to jail? What if you send someone else to jail when they shouldn't have been sent to jail? Lots of things to think about. There are some very valid reasons why public speaking is scary. But when you think about what makes people scared, I think it's really the fear of the unknown. And the more you can know about it, the less scary it will be. My goal in this podcast is to give you the information and advice you need to make testifying much less scary. So here we go. There are a few things you can do to get over that general fear of the courtroom. First, it would be good to get familiar with the courtroom. It wouldn't be a bad idea to take a half hour or an hour, go to your local courthouse, and just take a look around. Today, we'll take a peek virtually inside a typical courtroom to see what you will likely look at when you first walk in. It normally will be a fairly large room. Against the wall farthest from the door, farthest from you, often somewhat elevated, is a worktop or table and a chair. The judge's chair and workspace is usually the easiest space to identify, and that is going to be the spot upon which the rest of my description hinges. So, you figured out where the judge goes. Just down and in front of the judge are at least two other workspaces. There should be one with a chair and likely a screen directly in front of the judge. That is the clerk's space. Then to the right or to the left, depending on the courtroom, there is a microphone with like a dock area. Normally, there is no chair. That is the witness box. That is where you're going to go to testify. Now, if you have any physical concerns about standing for long periods of time, you should flag that to the court when you get there. In Edmonton, they expect you to stand the whole time. In the Northwest Territories, in Yellowknife, for example, the judges will very often kindly say to the witness, "Please sit if it makes you more comfortable." Now, don't think that the Yellowknife judges are just way nicer than the Edmonton judges. They might be, they might not be. I'm not saying in this. But the point is that the Yellowknife judges can still see the person testifying while that person is sitting, just due to the makeup of the courtroom. 2 days ago, in my 3-day sexual assault case, one of the Crown's witnesses complained about standing. She said she had a bad back. She had other bad things, but anyway, she was complaining then about her back, and I very kindly indicated that I had no objection to her sitting. She hadn't been cross-examined at that point yet, so I could maintain the appearance of a sweet, soft-spoken lawyer a little longer. But the judge said, "I have to see the witness." And actually, that was a witness you didn't want to miss. Later on, the Crown said she wasn't a likable witness. Like, that's an understatement. The judge said she was a character, and I added, yes, like a villain from a Marvel movie. I actually said that. Order. Order in the gallery. Back to testifying in court. In the next row, in front of the clerk and the witness box, are 2 tables. They're usually separated a bit apart. Those are for counsel, otherwise known as lawyers. Normally, Crown Counsel, the prosecution, will be at the table that is closest to the witness box. In front of counsel tables, you'll often see there is a metal bar. That is the bar that separates the public from the rest of the active court participants. It is also the bar that one refers to when someone says that a person has passed the bar. That means that they have been admitted to the bar, which means they've become a lawyer. So bar admission, all of those references to bar, that physical bar is what we're talking about. Okay, so now you know what the courtroom looks like. If you are a witness, normally you will be excluded from the courtroom before everything starts. So you'll be asked to wait outside. And once it's your turn, then you go in and you can testify. Once you've finished testifying, you are normally free to sit and watch the rest of the trial or to go home. The idea is that a witness who testifies should never have heard what another witness before them has said. That's why we normally have an order excluding all witnesses. Back to trying to get over your fear. We've now set out the courtroom. You know what it looks like. You know where people will be seated. You know where you're going to have to wait. There are a few other things you can do to make sure that things go smoothly. First, read your statement. You know, in that trial that I just got out of that lasted 3 days, it ended yesterday. My client was acquitted of all charges, by the way. 2 of the witnesses, Crown witnesses, they had not read their statements. And in fact, one of them, the villain from the Marvel movie, said she didn't need to read her statement. No, she didn't want to refresh her memory by reading her statement that morning. That makes her look like a witness who just doesn't really care. Don't be that witness. Don't be that accused. Read your statement ahead of time. Bring it with you the day of trial. Ask your lawyer, or if you're a Crown witness, the Crown, for a meeting to talk about what to expect at trial, how to testify in the best way possible, if this podcast didn't clear up all of your questions and concerns. Get lots of sleep, eat well, day of, dress as if you were going to a job interview or to church. So something nicer than what you would wear on a day off at home. This is a dressier occasion. A suit is not out of place, but if you're not comfortable in it, a nice pair of dress pants or a button-up shirt or a nice sweater is totally fine. Ladies, something between ballroom and night out on the town. Not too casual, not too dressy. Like I said, a suit is good. Nice dress, skirt, pants. Just, if you can avoid jeans, great. But if not, just make sure you're clean and presentable. Get to the courthouse early. You are going to be really flustered if you're running behind time and everyone is glaring at you when you get to the courtroom because you made everybody wait. You're just going to start off on a bad footing. I suggest get there about a half hour early. During that time, you can take a quick peek inside the courtroom to see what it looks like and see how it compares to what I told you about on the podcast. But for the rest of the time, you should be sitting outside the courtroom waiting for either your lawyer or the Crown prosecutor or someone to come and speak to you. If you are the accused person, and if you were accused of driving offenses, there are a few other things you have to keep in mind. Please do not drive yourself to the courthouse. If you are found guilty, there will likely be a driving prohibition, and then you and your car are going to get stranded at the courthouse. So please come with somebody else. The other thing I don't want you to do if you are the accused in an impaired driving situation in particular is walk around or talk to anybody, because the police can compare your speech and your walk with the day that they picked you up, and that is devastating evidence when they get it. So do not walk around and do not talk. Turn your cell phone off, because even if you are trying to adhere to what I've told you on this podcast, your phone goes off and you naturally want to answer answer it, someone's nervous about how things are going for you in court today, and you start speaking, and the connection isn't good, so you're speaking in a loud voice. Now everybody can hear you. You've now really ticked off your lawyer. Don't do that, because I want what's best for you. And what's best for you is not giving all the other witnesses an ample opportunity to hear you speaking. Even if you aren't the accused, or you aren't the accused in an impaired driving case, turn off your cell phone and turn off anything else that can possibly make noise. Because if one of those very helpful but noisy devices goes off, someone is going to be glaring at you again, and you're going to feel very uncomfortable and you might get flustered. While waiting, do not talk to the other witnesses, even if you know each other. In fact, I would suggest, especially if you know each other, you don't want anyone suggesting collusion. Okay, the moment has come where you're going to testify, and you may be thinking, oh my God, testifying? This sounds so complicated. It's not. Really, testifying is all about telling the judge another side of the story that they wouldn't know about unless you were there to tell it. It's all about communication. I often say it's a lot like sitting at a dinner table. And you would be comfortable sitting at a dinner table talking to people, right? Now, if we were sitting at a dinner table, you would never turn your back on one person and just completely speak to the other person, right? That would be rude. And we are Canadians. We are not rude. At a dinner table, we include everybody in the conversation. So, in the courtroom, don't forget the judge. And if this is a jury trial, don't forget the jury. So many people, when the question is coming to them, they look fixedly at the questioner and they're answering the question and they're not looking at the judge or the jury. And the judge is looking at them, but that communication piece that is so important is missing. So I will often give my clients a hint. I used to treat this as something of a secret, but now it's on legal eyes. So the hint is the witness will often catch my eye, and if you're my witness, I will give you this hint. I will look at you, I'll look at the trial judge. I'll look at you, I'll look at the trial judge. And it's just to say, get your gaze over there, because that's the person who counts. So you can literally ignore the person asking the question, you physically pivot and you turn to the trial judge and you say, Justice, in Alberta, because they're all called justices, Justice, this is how it happened. If you're in another place where you're provincial court, often it's Your Honor, but you get the idea. Why do I think that's so important? I think it is that much more difficult for the justice to say, I think Mr. So-and-so or Ms. So-and-so or Mick So-and-so was a complete liar if you were looking the judge in the eye the whole time. Communication is a multifaceted exercise. A lot of it is nonverbal. Okay, so you're at the witness stand. What's going to happen next? The clerk is going to swear or affirm you. Please, please do not say, it doesn't matter. Whatever. I don't care whether I'm sworn or affirmed. That answer drives me a little crazy. In a way, there is a difference. In a way, there is no difference. The way there is no difference is the courts will accord just as much weight to the testimony that is sworn as to testimony that is affirmed. But where it does make a difference is what is binding your conscience. If you believe in God, you should swear. So swearing is promising to God to tell the truth. Do you solemnly swear that the evidence you're about to give today is the truth, the whole truth, and nothing but the truth, so help you God? I do. You just swore. Not in the vulgar sense, but the legal sense. Affirming is promising solemnly to tell the truth, but not mentioning God. Do you solemnly affirm that the evidence you're about to give today is the truth, the whole truth, and nothing but the truth? I do so affirm. Or you can just say, I do, like in a marriage. Swearing or affirming, think about it ahead of time and be ready with your answer. And give it with confidence. I like it when people say, I'm going to swear or I'm going to affirm very clearly, because to me, it makes it feel like they know how important it is to be telling the truth. Moving on to the next chapter in Everything You Always Wanted to Know About Testifying, but were afraid to ask. Examination in Chief. The questioner is going to start asking you questions, and the questioner in this case will be, quote unquote, your lawyer. Now, if you are a witness for the prosecution, the Crown Prosecutor is not your lawyer. Think of it this way. Whoever brought you to court is the one who's going to start the questioning. So we're going to start with examination in chief, then we will move to cross-examination, then we'll move to re-examination in chief. And I'm going to explain to you what all of those look like. Once you got through all those, and if nobody else has any other questions, including the judge potentially, then you get to leave the stand, and we'll talk about what happens then. Examination in chief is composed of questions that invite you to tell your story. They are very open-ended questions, nothing that suggests a yes or a no answer. This is your time to really expand on what happened. The questioner will often ask you things like, and then what happened? And then what happened? The questioner's role at that point is quite limited, but it's your turn to tell what happened to the court. Don't forget, pivot, forget about the questioner, look at the trial judge, and tell the court what happened. If this is a jury trial, talk to the jury. Don't forget the jury. Look all of them in the eye as you're talking. Once examination in chief is finished, the questioner will sit down, and now the opposing lawyer will ask you questions. This is called cross-examination. And we are going to get into the minutiae of cross-examination in a bit. So cross-examination has a very different feel. These are yes or no questions. They are more pointed. It can be a little more uncomfortable, let's put it that way. And we're going to get into how to navigate cross-examination safely. Once you've finished cross-examination, phew, so happy that's over. I can leave now. Not necessarily. Hang on, don't leave right away, because the original questioner, your quote-unquote lawyer, may have questions arising from cross-examination. Now, those are not brand new questions. They literally have to have arisen from cross-examination. This is re-examination in chief, and since it doesn't take much time to explain it, I'm just going to do it now. The original questioner will often say something like, you heard my friend say this. And I just pause for a moment. Often people are confused. Why do the lawyers refer to each other like friends? Are they hanging out after this whole thing? I didn't want a lawyer who was going to be friends and all chummy with the opposition. No, we say my friend out of respect for the other lawyer, out of respect for the role that they play in the justice system. They may be friends, they may not be friends, and at that moment, they're maybe not that friendly, but especially in Edmonton, I am very proud to say the Crown and Defence Bar are very respectful and collegial towards each other, and in most places they are. I'm only going to touch on it briefly, but questions in re-examination in chief often start like, you heard my friend ask you this, I'm asking you da-da-da, and just try to think about what else could you tell the court about that point, or perhaps the opposing lawyer had stopped you before you were able to complete your thought, or the opposing lawyer didn't want you to continue telling us more about that part. That's where the original lawyer will give you that opportunity. So getting through examination in chief is pretty easy because you're being given pretty much free rein to tell all about what you need to talk to us about. if you are going to refer to your statement that you probably brought with you because I told you to bring it, ask first that you can do that. You should lay that statement face down on the table in front of you as you start to testify. But if you need it to refresh your memory with a detail, don't hesitate to ask. You just say, I'm sorry, can I refer to my statement? Because I think I have that noted, but I can't quite remember. Someone's going to ask you questions like, were those notes made at the time? Were they made while these events were fresh in your memory? Do you need those notes to refresh your memory in court today? Have they been altered or edited in any way? No? All good? Okay then. And the judge may ask the other side, have you seen a copy of this witness's statement? Yes? Then you may be given permission. Do not look at the statement before you are given permission. But once given permission, you don't have to keep asking, can I look at my statement again? You can just say, I need to refresh my memory by looking at my statement. And you can look and people say, go ahead, but you won't need to go through the whole exercise of, are you allowed? We just want to know when you're testifying from memory and when you're testifying from your notes. You'll get through examination in chief like a breeze. No problem. When your quote-unquote lawyer sits down and the other one stands up, things will feel a little different. But this podcast is all about getting you through cross-examination fine. The legitimate aims of cross-examination are to test your recollection, your reliability, and your honesty. So recollection is just, do you have a generally good memory, or is there something wrong with your memory? And frankly, if there is, be upfront about it. I can't believe how many clients I have lately who have concussion issues. A lot of concussed people out there, I will tell you. Or you might have had a stroke, or you may have another medical condition that interferes with your memory. Whatever it is, let your lawyer know. He or she can then make an informed decision about how to handle it. Reliability is anything that would get in the way of your normally good memory. Now, I often think about testifying as not just the dinner table, but also like a camera lens on a scene. And reliability is a collection of fuzzy filters that get put in front of the lens that make what would have been a clear picture less clear. So these are things like distance. You were too far away to see the person, or he was so up close you couldn't have missed it. Passage of time, lighting, no glasses, consumption of alcohol. So any of those factors that could negatively impact an otherwise good memory. Finally, honesty is just, are you trying to tell the truth, or are you trying to pull the wool over the court's eyes? That is not normally where people end up faltering. It's normally on number 2, the reliability part. And that's why we're going to focus a lot on that in how to navigate through cross-examination safely. Okay, let's get into it. I have a 3-part rule of thumb. If you stick to this, you should be safe as a church. There should be nothing that the Crown or the opposing lawyer can do to trip you up. Number 1, you tell the truth. That means you don't minimize anything, you don't exaggerate anything, you tell it exactly the way you remember it. Number 2, if you don't remember something, it's okay to say that. Your credibility does not go down just because you don't remember every detail, especially stupid details like what color were the officer's eyes? I don't know. It's okay. You don't have to know. But you do have to know if you were sexually assaulted. You do have to know if you ran into somebody, or if you hit someone over the head, or if you were hit over the head. But was it a Monday or a Tuesday? May not be all that important. So, number 1, tell the truth. Number 2, if you don't remember something, say it. Number 3, be careful of hearsay. If you weren't there to hear something or see something directly, let the court know that's the case. So if you stick to those three, you should be safe, but that's not the end of it. There are finer points that I want to go through. So picking up on that last point, sometimes you know something happened, but you know it indirectly. So you know A, B, and C happened, therefore D must have happened. Explain to the court what your reasoning is. The example I often give is, what time were you stopped by the officer? Around 6 o'clock. Is that a guess? Yeah. No, it is not a guess. There's nothing worse than a guess in criminal law. But I really don't think people are guessing very much. I think what's happening is your brain is working very, very quickly to figure out something. So slow that process down and ask yourself, why do I think that? Let's try that again. What time were you stopped by the officer? Around 6 o'clock. Is that a guess? No. My lawyer told me not to ever say yes. No, don't say that in court. No, I left work at 5:30. Nothing happened that was unusual that day. I didn't stop anywhere. And I know from experience that from my workplace to the place where I was stopped takes about a half hour. That's how I know without looking at a watch or a clock that it was around 6 o'clock that I was stopped by the officer. See? Not that hard. Now, there are some folks out there who really don't like to talk more than they need to. One-word answers, that suffices. Hate to say it, but it's typically my males, but sometimes it's also women. They just don't want to give that extra word. You can tell it's not hard to get an extra word out of me. I like talking, but some of my clients, they do not. And this is the point where I want you more communicative. Those extra details around what happened help. Yeah, I'd walked in and my friend was watching the hockey game. It was the Oilers versus the Pittsburgh Penguins, and Oilers were down 2-1 the Oilers were up 2-1. We are Oilers fans here. Oilers were up 2-1, and we were just about to get popcorn to celebrate what looked like a great victory over the Penguins when the assailant came in. This grounds the memory in context. Think about what was happening. What did you see at that time? What were you feeling? What was the temperature? What were the sights and smells out there? What were you hearing? Literally put yourself back in that position so that you can think about all those extra details that were happening at the time. The 5 W's: who, what, when, where, why. All those things that are happening at the time so that we know what you're testifying from is real memory. So, if you know A, B, C, and D happened, therefore E must have happened, explain to the court that's how you're drawing that inference or forming that deduction. If you didn't hear the question, ask that it be repeated. If you didn't understand the question, ask that it be rephrased. And you do that by simply saying, "I'm sorry, I don't understand your question." The person asking the question will normally rephrase it. They'll put it into different words. Now, if you get a brainless questioner who gives you exactly the same question in exactly the same way, or you get it in a different way, but you don't understand it any better the second time, a safe way to answer that question is to say, if this is your question, this would be my answer. So, for example, if you're asking me, did I potentially have 12 beer instead of 3? My answer would be yes. Boy, that's a bad answer. In any event, at least then, it's very clear what you think you're answering in your own mind, and at that point, I really don't care what the original question was. Is it possible questions? Is it possible questions are tricky because if that thought just popped through your head, anything's possible, yeah, maybe, maybe not. Is it possible you met the Easter Bunny going to work today? No? So not everything is possible. Is it possible that you have 5 beer instead of 4? Is it possible this happened at 8:35 instead of 8:30? Some things are very possible, some things aren't. It's possible that the sky is striped green and yellow outside right now. Is it likely? Nope. I have never seen it like that in my whole time on this earth. Was it like that the last time I looked? No. So that's what you do with is it possible questions. Bring it back to probability and recollection. How likely is it that that thing is possible? And what is your actual recollection of it? So for example, is it possible that you had 4 beer instead of 3? No, it's not possible. I was with cheap friends. I only had enough money for 3 beer and a taxi, of course, because I wasn't going to drive anywhere impaired, and no one was offering me any drinks, and that's why I remember having 3, and it's very unlikely that I had any more than 3. Or you can say, yeah, I was with a whole bunch of friends. It was my birthday, and they were all buying me drinks. I knew I had enough money for 1 drink. I can't quite remember whether it was 3 or 4. It is possible it was 4. One thing about your testimony, don't ever be scared about admitting something that maybe doesn't put you in the best light. Frankly, when my clients do that, they're the ones on the stand, I like it. I think it makes them look credible. Now, if the negative thing they admit to is actually the offense, I like it a lot less. But that's not what I'm talking about, because if you were going to admit to the whole offense, we would have pled you guilty in the beginning. They aren't trying to hide anything or put themselves in the best possible light. They're being upfront about where they might have screwed up on something. Be careful of common sense questions. I ask common sense questions in cross-examination, often mainly to see if I will get the common sense answer. It really makes a person look unreasonable and incredible if they don't give the common sense answer because I'm the person asking the question. The Crown's witness might think I'm laying a trap for them and think that the obvious answer can't possibly be the right one. Because the opposing lawyer is asking the question, they get scared. When I see that happening with a witness, I will use it to my advantage. I'll throw them a bone. I'll say something that actually would have assisted or backed up their version of events, and then sit back gleefully as they refuse to agree with me. Sometimes they say things like, I know where you're going with that question, and I always think, I know where you're going with that answer. A good example of a common sense question is, you'd agree with me that your memory doesn't get better with time, does it? Oh yes, my memory of these events is better now than the day it happened. Oh, sure it is, now that you've replayed it 50 times in your head and have twisted it into so many different versions. No. Often people don't want to agree with me because I'm the opposing lawyer. And that doesn't make them look good. So if it's a common sense question, give the common sense answer. Yeah, I'd agree with you that memory doesn't get better with time. But that's the generalization. Think about your specific situation. But you can add, my memory of these events is very clear because, and you can add whatever it is that makes it memorable. I've never been in the back of a police vehicle before, or I never saw an assault in my whole life. I was shocked when that person went down on the ground. I will not forget this for as long as I live. Don't do that. But you get the idea. If it's memorable for you, explain why. Listen very carefully to the question being asked. You'd agree with me that alcohol can affect memory? You'd agree with me that alcohol affected your memory? Whoa! Those are 2 very different questions with very different answers. You'd agree with me that alcohol can affect memory? Yep. That's that common sense question that we just talked about, and it has a common sense answer. Yes, I can agree that alcohol can affect memory. Did it affect mine that night? That is a different question, and in fact, it's the second question in my example. If the answer is yes, you should have told that to your lawyer ahead of time, and they might not have put you on the stand. If the answer is no, explain. But it didn't affect mine that night. My memory of these events is very clear. if it is. Or you can say, my memory of most of these events is very clear. Or, my memory of these events is not terrible. Be honest about how your memory is. Getting back to our example, you'd agree with me that alcohol affected your memory? That one is different. No. And you can say, I can agree that alcohol can affect memory, but did it affect mine that night? No, my memory of these events is clear. Or, my memory on this point is clear. When you are testifying, please keep in mind that this is a lot like radio. So when I say things like, he came up to me and then he raised his hand like this and went smash like that, and I fell back like this, and then when I tripped, I fell over here, and you're kind of like, this is really annoying because I can't figure out what's happening. Some lawyer in that situation is probably going to stand up and say, the witness just raised her right hand, made a fist, and is making a swinging motion towards her left. This comes up with distances too. Often a witness will say, I was this far away, and the lawyer will stand up and say, the witness is gesturing with his hands 2 feet apart. You do not have to agree. If you think that's 3.5 or 4 feet, say it. Or if you prefer to put it in metric terms, that's fine. We are Canadians. We love to mix up metric and imperial. Kilometers an hour is how fast we go down the highway, but I am 5 feet, 3 inches tall. Go figure. Or you can also use landmarks in the courtroom. I was from here to the judge's table when it happened. A lawyer might suggest to you that that is a distance of 20 feet. You can agree or disagree in either imperial or metric as you wish, because you are Canadian. That way we can see what's happening, because in court, we have to keep in mind a number of things, the accusations before the court, but also a possible appeal. And that next court needs to be able to see what's happening in the courtroom. That's why when I do something in the courtroom, I will often explain what I'm doing. I will say out loud, I'm handing the accused driver's license to the clerk of the court now. And everyone in the courtroom is thinking, of course we know that. We can see you. God, those lawyers are so wordy. But what I am doing is painting a picture for the next court. Getting back to radio, though, if I ask a question, did you see the person? They nodded their head. Did you hear that on the radio? No. So I will ask every time, is that a yes? Is that a no? I will often ask, I see you nodding your head, or I see you shaking your head. Is that a yes? Is that a no? Same thing goes for Now, in here on this podcast, I'm sure you can tell sounds like a yes. Sounds like a no. On a transcript, it all comes up as MMH or nothing. And that is not helpful. So we need to have your answer. And even if you get corrected multiple times and I have to keep saying, do you mean a yes? Is that a yes? Is that a no? Don't get flustered unless you are the opposing lawyer's witness, in which case, be flustered all you want. If you're my witness, don't be flustered. I'm just trying to make sure that it is clear on the record what the answer is. If you made a mistake, you said something and you realize now it was wrong, what do? Well, if the error is brought to your attention by opposing counsel and you realize you did make a mistake, admit it. Just own it. Don't beat around the bush or equivocate, or worse, stick obstinately to that one version that we all now know was likely incorrect. But give an explanation as to why you made the mistake if there is one. If, on the other hand, the error comes to you just as you're testifying, not as a result of a different version being put to you, I suggest don't ask if you can say something, because someone might just say, no, you can't say something. You're not up there just to ramble on about whatever you want. You're just there to answer questions. Blurt it out. I'm sorry, I said this. I really meant to say this. I'm just a little nervous. And everyone takes a little chill pill and says, okay, just a little nervous. It's all right. Don't do that too often, but if you really think it's important, then correct the record. I think it's a mark of a good witness when they're trying to make sure that their testimony is as accurate as possible. Getting back to this aspect of it being a little like radio, there is a record kept of everything that everyone said. There's no record kept of how quickly or how slowly you said it. Now, a good cross-examiner will often get you on a roll. Isn't it true that this happened? Yes, this, yes. And sometimes that witness is just now answering and not really thinking as much about their answers as they should. Don't let that happen to you. Now, as a witness, you will probably have a very handy-dandy prop right beside you. It's called a glass of water. Use it. Pick up that glass of water, take a sip as the question is being asked, and it lets you slow your brain down. It lets you process a little bit, take a deep breath, and then answer. Now, if you take an excessively long period of time and you are the opposing lawyer's witness, I will often say something like, why the long pause? I'm snarky that way, but I am still painting that picture. And if you start looking through something, I will say, it looks like you're looking through something to find the answer. So be careful. Make sure you are as responsive to the one lawyer's questions as you are to the other lawyer's questions. If to your quote-unquote lawyer's questions, the answers seem very reasonable, they all make sense, and it flows, but then to the other lawyer's questions, it's, I don't remember. Well, you just look terrible. So don't do that. Don't change your tone. Don't act snarky. Even if the opposing lawyer is driving you crazy, even if it seems like the questions are repetitive or they're stupid or they're insulting or you're starting to feel angry, keep your poker face on. Don't forget the foil technique. The more that lawyer is pressing or maybe even not being overly kind, that's not their job, don't forget, and the more respectful, polite, and courteous you look, well, the better you come off. So remain respectful, remain polite, remain responsive. Don't argue with the opposing counsel, don't get your back up, but don't be a doormat. There's a fine line. You can be assertive without being aggressive. I'm sorry, sir or ma'am, that's not the way that happened. That sounds really good. No, it wasn't like that. No, yes, no, yes, yes it was, no it wasn't, yes it was, no it wasn't. No one wants to hear that. They just don't. So just a very firm but calm, no, Your Honor, or no, Justice, that's not the way that happened. A nice way to sort of cut that off is, remember, turn, pivot, speak to the judge. Justice, that's not the way that happened. Fine. When you are recounting something that someone said, especially the bad guy in the story, don't start to do voices. Voices can be entertaining on radio, on podcasts, in movies, but not in court. I have a good example for you. My client was an older gentleman, and he was charged with assaulting police officers, even though we were arguing that he himself had been assaulted. When he got to the point when he was talking about his interaction with the officers, he told the court that the main officer who was nasty to him had said to him, "I'm going to put the cuffs on you." And everybody in the courtroom laughed. I am sure that's how he remembered it, but it didn't help his case. Don't do that. Just recount in a normal voice what someone said. If the tone was different or remarkable, you can let the court know that. And also recount word for word, to the best of your ability, what was said. I remember there was an interpreter who didn't like to interpret swear words. However, if the person swore, include the swear word in what you are saying. The court has heard it before. They won't be overly shocked. If you need a break, let somebody know. You're allowed to ask for a break. If you really had to use the washroom just as they called you up to the stand, you can ask, could I just quickly use the washroom before I go? Try and do that beforehand. But if you're in the middle of your testimony and you think you're going to be sick, please ask for a break. I had one witness who fell over during their testimony. It was cross-examination. I think it was just a low blood sugar, but eat well. Remember how I told you to eat well? There's a reason for that. I don't want you keeling over. That won't happen. This is just like a dinner conversation. Don't forget. Now, a Dumbo's feather. You keep this with you at all times. Remember, you are probably doing way better than you think you are. You are not a professional witness. This podcast does not certify you to be a professional witness. And so the court knows that you're nervous and that you're trying your best. Even though it may feel to you like you're stumbling and you didn't do a good job and you just sounded stupid, you probably did way better than you think you did. And just so you know, whatever you have said, your lawyer is going to try to turn it to your advantage. If you said something that was against your interest, well, you are a credible witness. Look, he or she candidly admitted That's great. If there were very significant contradictions between your evidence and that of another witness, there was no collusion. Nope, there was no collusion. There may have been very significant contradictions, but there was no collusion. Collusion being getting together and putting together a story with the other witness so that it all sounds like it works, but it's not true. That's not okay. Don't collude with anybody. Collusion, no. Once you start, if you do take that break that we were talking about, someone will likely warn you, but just in case they don't, I'm warning you now, do not talk to anyone about your evidence in the break. You don't even ask your quote-unquote lawyer about how things are going. Am I doing okay so far? No. We do not talk about that at all. Don't talk about it with anyone. Once you're finished testifying, if you are a witness, you are free to watch the rest of the trial or you're free to go home. If you're the accused, you'll go and sit back beside your counsel at counsel table. At the very end, when everything is done, the judge will often thank the witnesses. What the judge is doing is thanking you for doing your civic duty. It's not everybody, unfortunately, who comes to court when they are supposed to and who tells the court about what happened that day, but they are essential to our justice system working properly. Without that extra lens on the scene, the judge might not get to the right conclusion. So you're not there to help out your friend or to help yourself out. You're there for the administration of justice. I hate to say it, but the really painful part usually starts when you leave the courtroom. That's when you ask yourself, why did I say this? Why didn't I say that? I should have said this. There was so much more I could have said that. When they asked me this, I should have said, don't beat yourself up. Everyone who is asking questions is probably doing the same thing. Why didn't I ask that witness this? Why? There's the trial in the courtroom, and then there's the trial that happens in the shower later. Give yourself a break. You did fine. You were prepared. You were careful. How do I know? Well, you sought out the answers to everything you always wanted to know about testifying but was afraid to ask. Hopefully, with this podcast, you got some answers. We'll see you next time. Shannon Gunn Emery signing off.